You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
But we start with, lady's got a doctor's appointment, so we're going to take it. It's quite an extensive story, Dave. We have Jamie here. I'm going to run through her entry, and then she can fill in any blanks that you need, okay? My parents moved me into their second house 23 years ago while I was in college. Told me it was going to be my inheritance. Never made up a lease or anything. Never asked for rent. Only asked me to maintain the place, minor household repairs, yard, utilities, all that stuff, which she's done. Now they want me to pay for all major repairs and property taxes as well, which would be fine. But they're constantly telling her it's not her house, it's not her property. I have to ask permission to do anything, even like put things in the shed. And whenever I do something they don't like, they threaten to kick her out on the streets. Wow, it's not cool. And it gets worse, too. Also threaten to file grandparent rights to take my son. They say I withhold him if he doesn't go stay with them after school at least 3 times a week. They live 3 blocks away, and they see him on a regular basis. Jamie's single mom. Dad nowhere to be found, not getting child support. 2-3 jobs to keep her head above water. People tell me since there's no lease, looking to squatters' rights if they try to evict me. I don't think that works when I'm a family, and I was given permission. Just no lease or any kind of agreements. I just want to know my rights if they try to actually evict me and try to push the grandparent rights, and wanting to know their rights so I'm not completely blindsided. Supposedly they're going to sign the house over to me at the beginning of the year, but they have said that several times over the year. They kind of like a carrot in front of her face forever and ever. So what does she do?
Jamie.
Let's bring her up here. It's a hell of a story, Jamie. Good morning. Thanks for getting in touch with us.
Yeah, thank you.
How long has this been going on? Was it amicable for some time and then it just got sour recently, or has it been bad since day one, 23 years ago?
No, it's probably been within the last 10 or 11 years, probably since I had my son.
Are these...
That's when my mom's always had the control thing, but the house every other month or so, it's threatened to be taken away if I don't. Yeah.
So Jamie, we're talking
like I should be doing.
Are these your parents?
And then I had a friend helping me fix things around the house because the house is behind, out of code, and we went through the shed one day and we're taking things out everything was broken. There was broken picture frames and stuff because my parents have some stuff in the shed too from when they moved down here, and we were getting rid of the rusty nails, and that way if anybody went in there they didn't get hurt. Well, they said that we damaged the stuff. Well, they blamed my friend mostly. And then that's when they really started going crazy, saying it's not my house, it's not my shed. I have to ask permission before I do anything to it, even before I put stuff in the shed. They don't like when like I said, if my son's not there at least 3 times a week. They would rather have him every day, but then they're saying they don't see him enough, and I'm withholding him, and they're going to file grandparents' rights to take him away from me. And constantly, the bill thing, I don't mind. We had this last year, we had to replace the whole underneath of the pipes of the house, the furnace, the water heater, and I don't mind helping out on those bills. That's not a problem because I live there,
Right, and it's supposed to be yours eventually, so you want to take care of it. What do you got for her, David?
Right, yeah.
Hey, Jamie, this is David. I have 1,000 questions. I'll start with this. Are these your biological parents? I mean, they're the parents you grew up with?
Yeah, it's my mom and my stepdad. And my mom actually bought the house from my grandpa before she met my stepdad.
Okay.
It's been in my family since Blueprint.
Wow.
Now, okay. Did you grow up in this little house? Or I say little house, but I mean, there's this house that your mom bought from your grandpa. Is that the house you grew up in, or?
Partially.
Okay. All right. And then
when she met my stepdad, we moved out of town, and she rented it out to my aunt's boss. And then when I moved back down here to go to college and stuff, she moved me in the house because it was cheaper than getting an apartment or.
What happened with you guys? Do you know what's triggered this? I mean, is it relevant to this?
That way, she's always had a control thing, and I'm an only child, so it's even better. It's yay. And then, she's telling me that it's not too late to take me out of the will and take the house away. I need to watch what I'm doing because my son, he's going in junior high this year, so I'm letting him choose what he wants to do during the day. If he wants to go to family's house or friend's house, and
right.
that I'm withholding him, and therefore it's not too late to take me out of the will, and even though we spent almost every weekend with her for except this is last weekend we didn't, but she's saying that, telling everybody she hasn't seen us in over a month, and I'm withholding him.
Is your mom listening to this, do you think, right now?
Oh, God, no.
Okay. All right. Well, by the way,
first of all, is there such thing as grandparent rights? You can't say you have to give me my grandkid.
In the context of a divorce or custody situation, grandparents are allowed to file a petition to try to get access to the grandchildren. It's usually because the other parent is keeping the grandkids away from. Let's say mom and dad get divorced. The children are primarily with mom. Dad's parents want to see the kids more. But mom doesn't want the kids to see her ex-husband's parents out of spite, for example. There are situations, there's a statute that allows for the grandparents to file a petition to try to get some type of visitation. And it's usually in the court's discretion how that would play out. I've never heard of it in the context of a grandparent, parent to child, where there's no custody issue here. And so right now there's no matter in front of the court to begin with. Am I correct, Jamie? Where's your son's father in the picture here?
Oh, he doesn't even know he exists.
Okay. All right. So you have full custody. You have since day one, probably.
Yeah.
All right. I don't know. And again, this is my caveat. Every time I speak about things like this, there may be a family lawyer listening right now who is pulling their hair out saying, David, say this. You're missing this point. But I think in this context, there's really no opportunity for a grandparent to file for a court order absent some kind of showing that you are not a capable parent. And then there might be some kind of involuntary thing, an action that can be taken to try to bring the county in to show that the child, your son is, it's unsafe. I mean, there are a bunch of different things that could happen if that is the issue. And then at that point, the grandparents get involved as potential, custodians of the child during your rehabilitation period. I mean, I'm using some basic language here, but that's kind of the idea. I don't see any evidence of that based on what you have said. You just have a very upset mother who wants access to her grandson
and control of her life.
Right. She's irritated with you because you're just not dancing to her tune.
Yeah. This summer it's gotten really bad because she's got on some meds that have made her not very, she's got a lot of health problems, and she's been falling a lot lately with her health problems and stuff. So they've been messing with her meds, and so some of the meds have made her really slurring and falling asleep, almost like she's narcoleptic. And then she's mad because I won't let her drive with him in the car. I'm like, no, absolutely not.
Well, we've got two issues here. Well,
and so she's saying I'm withholding him for that too, and I'm like, no, that's putting his safety, and you shouldn't even be driving with all that stuff on board either.
Jamie, do you ever email your mom? I mean, is it?
No, because she comes after me hardcore. She has tried to punch me. My son's seen it 3 times in the last 2 years. She's never actually hit me as in the last 2 years. I can't, but she's tried.
But do you guys communicate via email at all? Would it be weird if you sent her an email?
No, not at all.
Yeah, the reason I bring that up too is because you may want to document some of this, because if your mother is having some medical issues, there may be a point where those resolve, and having some documentation of the conversations that you have had could be helpful to you in either repairing your relationship with your mom, helping to understand what you've been going through during this period of time, and establishing some of the commitments or the promises that have been made to you about the home too. Now, granted, there is a whole separate issue here having to do with this house that you have been living in, and whether or not you have the right to continue to stay there. Could she evict you? I mean, I think a couple of things. Number one, what is going to be the disposition of this home when she passes away? She has told you that she's going to give it to you. It's in her will. There are maybe better ways of her giving you this home. And by the way, is the home paid off, or is there a mortgage on this?
It has she's pulled out so many second mortgages on it. I think it has she said it should be paid off by January. That's when they're going to sign it over to me. Last I knew, she had like $18,000 left on it, but that was a few years ago when we had talked about them signing it over to me, and she was going to charge me $35,000 because she wanted to charge me for the fence they had built and the shed and everything that they have had done to the house.
Do you have any of that in writing?
Nope.
Okay. Well,
so for those people listening too about Jamie's problem here, it is a big thing is to get some of this somehow in writing or recorded or something, right?
You're right. When you're talking about people's plans, intents, yeah, whatever their intention is, I think it's always good to get that documented. It may not actually help. It may not be dispositive in the sense that it's conclusive that this is the intent and therefore this is what needs to happen. But it does help inform state of mind at the time certain decisions were made. I mean, you had an expectation of this, so therefore you repaired the shed, for example, or you cleaned out the shed because you had every expectation to think that this was going to be your permanent place, and that you had this kind of permissive relationship with respect to some of the maintenance at the house. You know, I could go through a list of the things that you might want to consider doing. Most of them involve bringing in a real estate attorney to help you put, for example, this house, or have your mother put this house into a trust, for example. Okay. And, a trust that could then name you as the beneficiary, for example. It could be a revocable trust so that your mother could still change her mind during the course of her lifetime. It could be an irrevocable trust. The minute that she puts it into this irrevocable trust and she names a trustee, it's no longer her property. It could be, any kind of rents received could be distributed to her as a beneficiary of this trust during her lifetime, at which point you become the beneficiary of the trust. And then, how the assets of the trust are disposed could be laid out in this trust agreement. It could be then that it's preserved for your son. There are tax implications to transferring real estate, to transferring property during life and during death. There are allowances, a certain amount of money, and it's pretty liberal. I think we're over $17 million now over the course of somebody's life can be transferred to a person, can be gifted to them without certain tax implications. Wow. But certain things have to be done. There have to be certificates filed. You have to really dot your I's and cross your T's when it comes to transferring property and dealing with the tax implications. And that's not to say that this would necessarily be tax-free. It might be if it's done the correct way. If it's done for some reason that she has a will and then she takes you out of the will, but she doesn't make provisions for the home in her will, the home may pass through some spousal components to the probate code to her new husband, your stepfather, that may be unintended. She may not really want that. So I think it's important that you try to broker a conversation with her, a lucid conversation, and say, look, Mom, we're clearly having some differences, and I want to do everything that I can to support you and your interests and your desires for this home. You understand the situation I am in. I've been living here. This is my expectation of the home. But if this is making you uncomfortable, Mom, what can we do? In fact, whether it's comfortable or not, if in fact you really do intend to do something with this home, let's get with a lawyer and let's just try to do this the correct way. And that will, I think, help ease some of the tension that you have with your mom, some of the controlling things. And then and explain to her, look, some of this has to do with my son. He's going into junior high. He's more independent now. He likes the time that he spends with you.
But as a junior high kid, you don't want to hang out with your grandparents all the time anyway.
He's got other interests too. So how can we include you in some of those other interests, or photos, videos, FaceTime on the days that he's not able to see you? That's a separate issue from the real estate. And that's more of just the human dynamic of trying to balance your relationship with your mom and your son. And it's a very difficult thing. You're kind of in that, what do they call it? The sandwich generation, or where you've got the parent that you're having to try to take care of, but yet she's also kind of taking care of you. You've got your son that you're definitely taking care of, and you're stuck in the middle here.
And he's stuck in the middle too, because when he does go over there, they play him and then they bash me to him. And then when they give the bills for both the furnace and the water heater, they hand it to him to give to me instead of giving it to me when I go to pick him up.
Passive aggressive.
Yeah, and I think some of that you just need to get some need to draw some boundaries.
Let's hope that come January the house paid off and everything goes smoothly and transitions into Jamie's hands. But let's go worst case scenario. Let's say manic episode this weekend. Mom says, get out of the house now. What's Jamie's rights after being there for 23 years?
Well, I think at this point you've got you're a tenant, and a landlord can't just unilaterally evict somebody because they are just irritated with them. There are certain steps
She tells me that she's not. She tells me that I'm not a tenant and she's not a landlord because I don't pay rent.
Well, I think you have. I would make the argument though that there's some kind of there's an implied tenancy that's been created here just because of the 20-year relationship to this thing. And I would try to stand firm if I were you, Jamie, and say, listen, Mom, you
can't kick me out.
Yeah, that's right. We have this relationship. I know I'm not paying rent, but I'm providing other things for you. And you've provided this for me, so you're going to need to follow the steps to evict me because I believe that I am a tenant. And again, I would suggest that you get with a real estate attorney to deal with that issue as well. And that is one that you would probably need to pay for. Creating the trust is something that, that really is going to fall on your mother because it is her property. And the reason I asked if it's paid off is because the terms of any home equity line that she might have, these other mortgages that she might have, might control the disposition of the property. It may prevent just a unilateral transfer right now. Putting it into trust can help with some of that too, because the expectation would be, I guess, that she continues to make these payments because she's the obligor. Or obligee. That's one of those things where I always get the O's and the E's backwards. And we all have something that we get backwards. Ross, it's just how you live life.
All right. My pants.
Yep, your pants and your shirt today.
Sometimes, yeah. Inside out shirt guy sometimes.
Oh, listen. So that's just what I would suggest.
But at the very least, if she threatens, she tells you to get out, you don't have to get out, Jamie.
That's the position I would take.
That's my biggest fear.
Yeah.
Right?
Yeah, especially with everything so expensive right now.
Right. And just try to find a place at the drop of a hat. It's not something that she can force upon you, especially after 23 years living in that house. So you've got something there for sure. I hope it clears up. Hopefully you guys can just find peace between one another.
Yeah, I hope so, but I sadly don't see that happening because it's just getting more and more aggressive as the years go on. So,
how old is she, by the way?
67.
Okay. All right. Well, hey, Jamie, keep us posted if you need any more help moving on from here, and we wish the best of luck, okay?
All right. Thank you so much.
All right. Thanks.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
Who is this? Citizen Mary, insurance agent, just did a policy review with me, and I was told my currently bodily injury liability, which is set at $100,000, $300,000, is too low. And if I was in an accident, I could be responsible for anything over $100,000. He suggested I change to the $250,000/$500,000. What do these numbers mean in the first place? I have no idea. And do I need to change to a larger liability amount? What is the 100, 300, and 250, 500,000?
These are great questions, and I'm glad, Citizen Mayor, that you're paying attention to this because this is very important. And if you are driving or you're a passenger on the road, you want to make sure that you're adequately insured.
Okay.
So what it means right now, you have $100,000 of bodily injury liability coverage. The 300, we'll get to that in a second, but basically what it means is if you cause a crash, you're responsible, Mary, and somebody is injured, their injuries exceed a value of $100,000, and that includes everything from the medical bills, so any surgeries that they may require because
that's like
they
one
got
night
hurt.
in the hospital these days.
One night in the hospital, that's right. Or if they're hurt, and these are, cars go fast, they cause crashes, people get very hurt. If they're off of work for a period of time, if there's any permanency, they're going to walk with a limp for the rest of their life. Their damages far exceed $100,000. And so if they pursue a claim against you and they get a jury verdict in excess of $100,000, and let's just say it's $800,000 is what the verdict is, that means your insurance would pay theoretically the $100,000, but the other $700,000 falls on you. And you have got to come up with that money somehow. And it's obviously a very tricky situation, and that's not always going to happen because just the way that negotiations work with attorneys and insurance companies, if the insurance company does the right thing and you don't have any assets, it's very unlikely if the insurance company pays that amount that you're going to be taken to court and they're going to get a judgment in excess of that. But it could happen. And if you have any kind of assets, it most certainly would happen then.
Like if you have a house, if you own your house, or
well, yeah, but it depends on the value of the home because there are certain homestead exemptions for bankruptcy. But I'm using the word bankruptcy now because it could be very serious. So that $300,000, which is appended to the end of the $100,000, you'll see there is a $100,000 per person, $300,000 per claim. So if you cause a crash and there are 4 people in the car that you T-bone at an intersection, and all 4 of those people are injured, that your policy of $300,000 would cover everybody in aggregate in that car, up to $300,000.
Wow.
But if 3 of the 4 have life-altering injuries, then their claims in aggregate could be $2 million. So you were really a little bit more limited there with what your insurance policy would cover. So again, you're going to be on the hook for anything above the $300,000. What your insurance agent is recommending is a very sensible thing to do. It usually does not cost a lot more money to do it, but to increase your insurance rate, your rates will go, no, not your rates, their premiums will go up a little bit. But to increase the coverage that you have to $250,000 per person who's injured in that crash, or $500,000 for the crash as a whole.
But even that seems too little, right?
Well,
at what point do you? I mean, because you could. I don't know.
Yeah, well, then you
this is
start working
baffling.
on the odds, and there's a good chance that it can that money could satisfy a far more greater number of claims. I will tell you this, Mary, you didn't ask this, but I hope you're listening because this is very important, and I hope everybody who is listening right now pays attention to this. It is not enough to just have that type of coverage for your insurance, your auto insurance, which is your bodily injury liability coverage. It is equally, if not more important, that you also add, and it does not cost a lot more money, underinsured, uninsured motorist coverage, which protects you if you are hurt in a crash.
And they only have $100,000 per person.
That's right. And so what I would recommend is that get at least do the $250,000, $500,000 for the liability, and ensure then that you have UM or UIM, which is what uninsured, underinsured coverage of at least that amount as well. So pay the extra amount, because that means if somebody hits you and you're the one with the medical bills, you're the one with the life-changing injuries, that you have at least, you can go after that person's insurance policy, and if they don't have enough insurance, you can at least go to your own insurance policy and get up to $250,000 of additional money to cover you. When it comes to uninsured policies, they will typically, insurance companies won't sell you more uninsured coverage for you than you are providing to somebody else for your liability coverage. So the more that you pay for liability coverage, the more you're eligible to then buy for yourself. And again, that is incrementally not that much more money. Because we deal with this every day, I cannot tell you how many people come to us with life-altering injuries. Their lives are changed, but they didn't have enough of their own insurance to help put some of those pieces back together, because the person who hit them is either uninsured or doesn't have enough insurance. So the takeaway, Mary, is go with the extra policy, go with the extra amount, and make sure that you have UM or uninsured, underinsured motorist coverage on the policy.
I know that you would own that one. Slam dunk. Slam dunk. That's your court right there, huh?
I'm in my court right now.
All right. Let's see. We're going to find out more about no soliciting / no trespassing signs. But first, let's get to another one I'm sure you're well into. Citizen Diego recently got his DUI, went to detox voluntarily. I'm starting a partial inpatient hospitalization, no criminal record. And then his question, will a slow pay lawyer be the way to go? What is a slow pay lawyer, and is it Diego's best bet?
I'll tell you what.
What is a slow lawyer?
You're listening to him right now. I'm slow.
I get it.
No. How bad was that joke?
In the middle.
Okay. Do we have a laugh track?
We got this again. We got this.
All right.
I should have given you this, though.
I'll be here all week.
His kids are at camp, so he's got to do dad jokes somewhere, everyone.
Listen, my kids are at camp for a month right now. I am on my own trying to figure out what to do with my life. Every night I go home, I'm like, all right. Well, I guess thank God for Netflix. All right. So,
Dave's Netflix and chilling by himself. All right, what's a slow lawyer for real?
Okay,
a slow pay lawyer.
A slow pay lawyer. I think that's anybody's guess. I am guessing that a slow pay lawyer is somebody that you pay slowly. A lawyer that is willing to take a pay.
I could have figured that out.
Well, listen, Ross, I don't know. I mean, go to law school. Lesson number 1. Do you want to be a slow pay lawyer?
The answer is no.
I don't think
you should get your cash up front just in case your guy goes to the chair.
Well, listen, and oftentimes the lawyers who help people who have DUIs charge a retainer up front, so that they make sure that there's enough money for them to proceed forward, file all the motions, do everything that they need to do to defend their client. And then and then they bill by the hour and they take that money out of the retainer. So they might say, okay, I'll take your case, but I need a $5,000 retainer. So then you write them a check for $5,000. That $5,000 goes into a special escrow account, and the lawyer begins working on the case. And so every time that they, put in an hour of work and they charge, $200 an hour, or $300 an hour, $150, $400, whatever they're charging per hour, they make a note of that. And at some point they draw down periodically against that money in the escrow account for all the hours that they work. And if they call you 3 days later and they say, look, I've put 5 hours of time into this case, but I just don't think I'm the right lawyer for you, then they'll be paid for that time out of the escrow account, and they'll give the rest back to you. A slow pay lawyer presumably is just somebody that will take a check here, take a check there, take a check a little bit later. But what Diego's basically saying is, I think that Diego's voluntarily, you said, checked into...
inpatient hospitalization.
Okay, that is...
To get help for his drinking.
All right, so is that inpatient for... this could be a couple of different things, and Diego, you don't need to tell us, but... When I see somebody talk about inpatient, it could be inpatient rehab, it could be inpatient mental health treatment. But if we're talking about just inpatient, things like that I think are very helpful as you look at trying to convince the court to maybe be lenient when it comes to sentencing for the DUI. If you are pleading guilty to the DUI, I just don't know what Diego wants to do as far as challenging this DUI. But
it doesn't seem like he's putting up a challenge. I think he realizes he had a problem.
Yeah,
especially going to detox
so.
voluntarily right away like that.
So you have a couple of different things. Certainly, I think I rarely hear people say that I hired a lawyer to help me with my DUI, and I think I got a worse deal than I would have if I'd done it myself. That's really unusual. Typically the lawyers can help. They know the courts. They know the different protocols for dealing with potential sentencing ramifications, what the penalties will be, and they can work to try to help minimize the impact on you from this DUI. There is obviously a cost, and that's why you're concerned about the slow pay lawyer, because you probably can't maybe come up with a retainer. You can do it yourself as well, and it's more likely to perhaps face a stiffer penalty because you may not have the experience of the negotiating and what your options really might be. I think it may be worth trying to at least consult with an attorney who does DUI work. They may charge, for an hour of their time to just consult with them. But I would start with that.
Yeah, even Google doesn't know what a slow pay lawyer is. It's not a thing.
No, I've honestly myself never really heard of that. So, well, this kind of sounds fun.
For those who don't know, what is the cost of a DUI now? Like $13,000.
Well, according to the billboards you see on the highway, it's about $12,500. But that typically factors in the cost of the attorney, the fines. What it doesn't factor in is
paying off judges.
Well, that's
stuff like that.
There's no ceiling on that.
Well, at least you're getting the help you need there, Diego, and probably good you got caught before something worse happened, huh?
Yeah, I just wonder about the inpatient thing. It makes it sound like there may be a deeper issue here, and so I think it's good that you're getting help. That's the most important thing, is to try to and stay off the roads. If you've been drinking, just stay off the roads.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
All right, 94.3 Kilo. We're back on the clock with the Law Frog. Our man hangs out. I'm trying to get your theme music playing. I just can't get it to work, my friend. Breaking the law. We've helped out quite a few here today. We get to an interesting one with Citizen James.
Spreading pixie dust of law all over people.
Right.
Bathing in the sprinkles of it.
Stamping the law straight. And one more segment here to go. James called, and he asked the question. I was like, you know what? I don't know, but I want to know. And you were like, I want to know, too.
I'm the same way. So, James, are you on the line here?
Let's see here. I got him here. Hey, morning, James. How's it going, buddy?
Oh, not too bad.
Cool. Thanks for bringing this to the table here. This is going to be an awesome question.
Ask the question we all ask all the time.
Yeah, give us the scenario you gave me earlier, James.
Well, we bought a home last year, and we've been remodeling, so now that it looks nice outside, everybody wants to approach and sell us stuff. So I went and bought a no soliciting sign and put it on the door. Well, it didn't change anything, so most of the time it happens when I'm not home. My wife doesn't answer it, and then they go away. Well, the other night I was home, and I answer the door, and the guy says, I'm not selling anything, but would you take a look at this so you know the spiel? And I pointed at the sign. I said, there's a no soliciting sign here. We get you guys weekly around here. And he just laughs at me, and he goes, we don't pay attention to those. If you had a no trespassing sign, that's what you need. And he says, have a nice day, and walks off. Like, what?
Well, I have the same question. So, James, here's what I have. I have a small little walkway from the sidewalk up to my front door. And at the end of the walkway where you kind of meet the public sidewalk is a little gate. And the gate is secured by two, brick pillars, one on either side. And on one of the pillars is a really gorgeous metal sign with kind of embossed lettering. And it says, unless you're selling Thin Mints, no soliciting.
Okay.
I love that sign. I inherited that sign from the prior owners. I have so many people who park, because I live near a public park. So the people will park and then they'll walk by, they'll see my sign. If I'm outside, they're like, oh, I love that sign, man. That is the coolest part of your house. And I think, I just spent all of this money to remodel this house. And the thing you think is the coolest thing is like this $20 sign that I inherited.
Dude, Girl Scout humor is hilarious.
I love it. Now, that has stopped absolutely nobody from actually affirmatively opening my gate and walking up and knocking on my door. And it really irritates me. It irritates me. So I'm in the same boat. But you know what?
He's mad as hell, and he's not going to take it anymore.
But this is what I did do because of your question. I sometimes wonder about this, but I'm so busy. I never think to look, well, what is the rule on this? And I think, from my understanding, is that every municipality, might or may or may not have an ordinance that speaks to this.
Okay.
And so while we were on break, we looked into this. I've got an attorney helping me do some research on this issue. And you'd think I would know this, but it's just one of these things that just kind of the same way like my car, when I lock it, it doesn't make the little beep sound anymore. I just need to turn that function on, but I'm so busy at it, I don't get to it. I've been so busy, I've never looked at this, James, but I think Colorado Springs does have an ordinance that says it's unlawful to engage in solicitation on any private or residential property after having been asked to leave or having been asked to refrain from soliciting by the owner. Displaying,
which would be a sign or verbal.
Here we go. Displaying a no soliciting sign constitutes a request to refrain from soliciting. Now, I haven't put. I've asked somebody to do some research here. I haven't put eyes on this myself, but from what I understand, the first offense is a fine of not more than $500, and the second offense is a fine of not more than $500 or imprisonment for a period of not more than 90 days, or a sentence of probation, or a combination of all three: money, jail, probation, possibly for a second offense.
Wow.
Now, okay. There may be some attorney in Colorado Springs who does a lot of municipal ordinance work and will say that you've stumbled on the wrong thing, researcher. But the trick for you is to get their information and then just say, hey, and by the way, I will be reporting this to the police, I guess. I mean, that's the thing. Like, how do you? What's the next step?
Yeah.
And I think that's what you do.
Right. So you'd have to document. You have to document you telling them once again, and then it'd have to be the same person coming back to your home soliciting that you could charge them. Right?
Yeah, that would be it. I think you could probably get away with the same company.
Okay.
Yeah, I think you could do that, but you'd have to document that you'd put them on notice too. So
basically, it's one of those deals where you gotta kind of threaten them in a way, but legally. But you need to be able to go to the police or an attorney. To me, the police isn't an option because on another subject matter, the hellscape out in front of everyone's house, everybody fights this all the time.
The what?
The hellscape, the grass in between the sidewalk and the actual street.
Oh, yes. Yeah.
So everybody comes, that's another issue. People come by with their dogs. You have signs that say no poopy, no peeing, and they let their dog in your yard in the hellscape, and you walk out and say, hey, please don't do that. They just smile and keep going. But to get that actually enforced, you're going to get an eye roll if you call the cops and say, this guy came to my house and I don't want him here.
James, have you ever seen the show Billions?
No.
Okay. Well, my kids are at summer camp right now, so I've been watching some TV.
What is it? I haven't seen it either.
It's on Showtime, but you can get it on the Paramount Plus streaming app. But it's kind of like Succession in the sense that it's about billionaires. And it has to do with this particular, he's the U.S. attorney for the Southern District of New York. And he's prosecuting a case against a hedge fund billionaire. So our Southern District of New York attorney is very, very serious. He is very law-abiding. And he's out walking his dog, and this neighbor of his, they live in an apartment building, his neighbor comes out, and every day his dog poops on the sidewalk right there. And it really irritates our lawyer. So he tells him, he stops him. He's like, excuse me, buddy, your dog just pooped. He's like, oh, yeah, sorry, man, I don't have any doggy poop bags. And he's like, no, you need to pick it up. He's like, oh, I don't have any bags. He's like, you need to pick it up. And he intimidates the guy with just his glare and also his stature as, I guess, a U.S. attorney for the Southern District of New York, which most of us don't know who that person would be. But this guy's like, oh, my gosh, you're that lawyer. He's like, you better I am, and you better pick it up. Makes the guy pick it up with his hands. All right? And then from that day forward, the guy's always bringing his doggy bag with him. But he was accompanied. I mean, when he first requested it, the eye roll was like, all right, come on, man. It's just a dog. Like, I'm just going to keep walking. And the guy's like, no, you're not. But you're right. It's hard to enforce some of this stuff. And I think having good relationships with neighbors is helpful. And then, you could, assuming our little ordinance here is correct. And I want to look into that. I wish I knew this. I really do. I wish I felt more comfortable with this answer. But you could post a penalty. You could have a little sign that says, by the way, a violation.
Just have a quick card, James. Then when the next time they show up, then they get their name and their company number, and more than likely they'll put you on some kind of a no-call list.
Yeah. Well,
yeah, that's what I was hoping, is just kind of start thinning the herd, so to speak. When I did some reading on it, it's real vague. It basically, what I came across said the First Amendment gives anyone a right to run around and go door to door. But on the other side of it, as a homeowner, you have the right to refuse entry on your property to anyone. So when you put up those signs, that's where it gets vague when you're reading anywhere. It doesn't matter the state or anything to do with that. They all kind of dictate that the no soliciting and the no trespassing are one and the same on a private dwelling. It gets different if it was a commercial building or something like that. But
that's right.
They've walked off the sidewalk, down my sidewalk, up the porch, read the sign, and proceeded to beat on my door.
Aggressive solicitation is disturbing and disruptive to residents and businesses and impacts social harmony and economic viability of the city of Colorado Springs. It is not the purpose of this section to prohibit lawful solicitation activity, but to regulate behaviors that are intimidating, threatening, coercive, or obscene. This is the Colorado Springs Municipal Code 9.2.111. How about that?
That's all you need is that. Throw them the numbers and scare the hell out of them.
Now, this talks about public place, but I think this is the one that talks about, well, this is the, listen, that's the public place one.
Yeah, take off your shirt and rub your nipples. Do that a couple times, no one will come by your house ever again, James. Trust me.
Yeah, just come out in the pink bathrobe and
like Cousin Eddie. Exactly. Yeah. Eating bacon, rubbing the belly. So, man, interesting question, though, James. Thanks for bringing that to the table this week.
Yeah, that's that 9.2.111, I think, is a public place. But I think the other one we mentioned has to do with...
Also as a public code?
Yeah, the private residence.
And once again, we learn law is hard.
Yeah, there's so many gray areas in there that everyone kind of just, like you said, the eye roll, and they kind of tiptoe around everything when you think you're covered, but you don't know that you are.
Fascinating. Okay, we're almost out of time.
It's been fun.
Well, I appreciate it.
Yeah, well, James, we've left you with some really vague answers here. very, very, very vague.
Pull up the official statute and then just quote that to people, and I bet they'll scare them off,
We think it's illegal, James.
Thank you for listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM, presented by McDivitt Law Firm.